Okay. Hello, everybody. We are live, and I am Sophie Stella-Bourdillon, co-director of the Brussels Privacy Hub. And I have the pleasure to moderate this panel today, which is devoted to all things data transfers. Thank you everyone for spending your evening tea or maybe your early happy hour with us today. By now, you've surely heard the phrase risk-based approach tossed around in discussions about international data transfers many times. And often, I suspect, without being entirely clear on what the speaker had in mind. And perhaps you've decided to join this webinar to demystify the risk-based approach for the rest of us today, and we'll share your views during the Q&A session. We are counting on you. But wait, let's take 3 minutes and a half for a very brief introduction and a warm welcome to our speakers. And let me set the scene as much as I can. So since the 2020 judgment of the Court of Justice in the Schrems II case, much has been said about what exactly a risk-based approach to data transfers means or should mean. And today, I'd say the debate remains as lively as ever, with advocates of a so-called pragmatic approach arguing against proponents of a stricter stance, often labeled as absolutist. And national supervisory authorities have thus faced criticism for what the pragmatists perceive as outright bans on personal data transfers to certain third countries, and in particular to the United States. In particular, national supervisory authorities have been criticized for having adopted a zero-risk approach to data transfers, not to be confused with a zero-trust approach, which seems to be much more popular. And it has been noted that this zero-risk approach may not fully align with national courts' positions. Today, we are here to discuss one of the supervisory authority decisions, the Uber decision issued by the Dutch Supervisory Authority last July, which has recently been appealed and will likely provide the Court of Justice an opportunity to clarify a few useful concepts, which is certainly a welcome development. Unsurprisingly, the Uber decision has given commentators yet another chance to voice their passions, and perhaps more intriguingly, I'd say this decision seems to have also set alarm bells ringing within the European Commission, which has now clarified that it is indeed working on another set of model clauses, this time tailored specifically for GDPR-bound data importers. Nikolaos Theodorakis, or Nick, partner at Wilson Sonsini and lecturer at Oxford University, is here to discuss the Uber decision with us today and hopefully will trigger some interesting follow-up questions from you in the audience. In the meantime, other rather energetic jurisdictions have been adopting their own set of model clauses, looking at what their peers have been doing in the space and progressively developing and maturing their own approach to these questions. And this is the case of Brazil, and we are very fortunate to have with us Lucas Anjos, representing the ANPD, who will give an overview of where Brazil stands today, reviewing its set of model clauses, whether they can make it work with one set or not, and maybe Lucas will also spare a few words on the adequacy process. And then, moving beyond Brazil and hoping to comprehend an important section of the global landscape, or shall I say simply a not insignificant part of it, we will, together with Giuseppe Bianco, representing the OECD, do a deep dive into the Data Free Flow with Trust initiative, as it is important to better understand what this concept is about and what it is that it could really achieve in an age of, and here I'll try to be careful, increased polarization. But without further ado, let's start with the Uber decision. Nick, the Uber decision is raising many questions. First, there is clearly an attempt to ground the reasoning on a very detailed analysis of the data flows and data protection rules, which is in part informed by the asymmetry that exists between Uber and its drivers. Is this analysis convincing? And could it be that Uber had actually a way to make the processing merely internal, to use the words of the ADPB? Second, if we forget for a minute GDPR formalism, assuming there is such a thing, in Uber there's lots of sensitive or special category data with profiling and automated sorting and scoring, which could lead to exclusion from the platform. So just to state the obvious, this is not a case about pseudonymized or de-identified usage data that would be used for product improvements, say, or system telemetry data that would be used for network or application security purposes. Might be very naive, but if we are serious about a risk-based approach, then these things should make us think twice. And third, the AEP gives a far-reaching interpretation of the principle of necessity applied in the context of a Chapter 5 derogation, which is essentially saying that efficiency, which leads to the centralization of the architecture and not its federation, cannot make a processing necessary for the performance of a contract without more considerations. What would be other conclusive considerations? But before getting caught by the details, let's start with the very beginning. Nick, can you say a few words about the types of processing that are at stake in Uber, the definition of transfer maybe that is being used in this case, and the overall reasoning of the supervisory authority in this case? Nick, the floor is yours. Thank you.
Definitely happy to. And let me start by thanking you, Sophie, and the Brussels Privacy Hub for inviting me. It's always a pleasure to be part in these events, and I very much look forward to a very fruitful discussion today. As you mentioned, this is a very interesting case, and I'll spend the next few minutes going through the basic levels and issues that were discussed in the case, and then happy to take any questions. But in a nutshell, it's kind of the everlasting battle between the so-called risk-based approach, as you mentioned, Sophie, and the belt and suspenders approach. I think in this case, the belt and suspenders approach was the one that won. We'll see what will happen in the appeal, of course, but for now, it sounds like the proponents of the belt and suspenders approach have something to celebrate. I'll share my screen because I've prepared a presentation. All right. So the Uber case. We see here an excerpt from the decision of the Dutch DPA, which imposed a fine of 290 million euros on Uber. This is the largest issued fine of the Dutch DPA to date. So it signifies the importance that this decision has for the Dutch DPA and the gravity that they dealt with it, and that they felt that there was an alleged violation from Uber. To set the scene a bit, even though Sophie explained that very well, that was with respect to data transfer that happened after the privacy shield invalidation and before the DPF. Because as you can see in this excerpt, it mentions that in the meantime, Uber has ended the violation because it has certified to the DPF, to the data privacy framework. So it's when there was a legal vacuum where we did have the SCCs, we didn't have the privacy shield. Many companies were experimenting with also relying on the derogation, something that was not really discovered until that point in time, until 2020. And this case exemplifies what happens if a company actually adopts that risk-based approach. In this case, the Dutch DPA disagreed with that risk-based approach. If we break that down a bit, there were two key scenarios that the Dutch DPA discussed in this decision, and that was the processing under investigation. The first one was a direct data collection from individuals based in the EU. So in this case, we had prospective Uber drivers who provided their personal data when they signed up through the Uber app. There was a direct data collection and storage on Uber service in the US, and there was no European Uber subsidiary that was involved in that processing. So that is a simple B2C type of direct collection of data from the EU. The second scenario was when Uber drivers were exercising their data subject rights. So in this case, the data flow was that a driver who was located in the European Economic Area files a data subject request, for example, a data access request. That request was then flowed to the Dutch Uber entity, which assessed the DSR and communicated that with the Uber US entity. So in that case, we had a data transfer from the individual user in Europe to Uber in the Netherlands, and then from there to Uber in the US. So these were the two key processing scenarios under discussion. And we have listed here the different position of the parties with respect to these data flows or data transfers, depending on what you're a proponent of. Uber's initial position was that there is no need to apply transfer safeguards because Article 3 of the GDPR already applies to the processing. In other words, Uber said that because of the fact that Uber is subject to the GDPR, there is no reason to add those onerous provisions with respect to data transfers of Chapter 5. And they even invoke WTO-related arguments, World Trade Organization-related arguments, and in particular GATS with respect to a provision of services, saying that it would be unduly burdensome for Uber to, and for any company that is otherwise directly subject to the GDPR, to have to take those extra measures compared to companies based in Europe that don't have to do that. The Dutch DPA's position was that that transfer safeguards must be implemented even when Article 3 of the GDPR applies, because it is difficult to enforce the GDPR in third countries. So it invoked something that we also find in the EDPB guidelines, saying that because of the fact that some countries may not follow the democratic rule of law, it may be difficult to apply those standards abroad. So we need to have those extra safeguards in order to ensure that we can adequately protect the data. So it doesn't have to do with imposing unduly burdensome obligations to companies, but rather with ensuring the protection of the data no matter what. Uber's position was also that the processing per se does not involve a transfer as defined by the ADPB, because both the Dutch entity and the US entity are subject to the GDPR as joint controllers. And also because in the first scenario that we mentioned, we have a direct data collection from an individual. And the EDPB guidelines include an example where they say that this would not classify as a transfer, and that was Uber's position. The Dutch DPA's position, on the other hand, was that the processing does involve a transfer of data, and that any movement of personal data from the EU to an entity in a third country qualifies as a transfer under the GDPR. And even though the GDPR itself does not define a data transfer, which is one of the reasons why we've seen kind of this turmoil and this back and forth, the Dutch DPA's interpretation was that from the moment we have data being exported from the EU, no matter what happens, no matter if the entity is or is not subject to the GDPR, we do have a data transfer. Finally, Uber said that even if the processing does involve transfers, Uber can rely on derogations, and they listed 2 derogations as an example of that we'll see in a second. However, the Dutch DPA's position was that Uber cannot rely on these derogations because, one, we're not talking about an incidental transfer that happened randomly, but rather a continuous business transfer. And secondly, because the transfer is not objectively indispensable for the performance of a contract. And there we see that the Dutch DPA had a rather narrow interpretation of what is necessary to perform the contract. If we dive a bit more into these items of the derogations, because they're particularly interesting, we're talking about 2 different derogations here. And again, if we look back in 2021, that was a time when many companies were trying to explore their options. And we're thinking that derogations may be a good way forward until we have something new like the DPF that we eventually have. So the derogation relied on by Uber, one of them was that it's necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures. Uber's position was that they can use this derogation in specific cases, and that the GDPR derogation should not be interpreted in a narrow way, but rather in a broader way, because the idea is that we should be allowed to rely on derogations when we otherwise cannot rely on other safeguards, or it's not appropriate to rely on other safeguards. However, the Dutch DPA's interpretation was that the EU legislators' intention, which generally aligns with settled case law by the Court of Justice, was that derogations are only available to justify incidental transfers. So it's really an exception. It's not something that we can rely on a daily basis if we systematically and repetitively transfer data in the course of an ongoing business relationship, but rather if it's something that really happens on an ad hoc basis, something that we wouldn't otherwise normally expect, that's the only case in which we could rely on the derogation. Otherwise, we cannot. The second discussion with respect to derogations here was that, again, in Uber's position, and Uber's position has been that the processing is necessary to perform the contract with the driver, because the transfer takes place in the context of the agreements between the different entities in Uber in the Netherlands and the US. And there is a centralized data processing in the US, which is crucial, according to Uber, for Uber to be able to provide its services and offer a same level of protection across the board as is offered in the EU. However, the Dutch DPA's interpretation was more narrow here with respect to what is necessary to perform the contract. And they used the benchmark of something that is objectively indispensable. And we can already tell that this is a very hard threshold to meet practically. And the Dutch DPA therefore said that Uber cannot rely on that derogation because the transfer is not strictly necessary to implement the agreement, because the existence of the agreement alone does not make the transfer necessary, and also because centralizing data processing in the US is driven by added efficiency for storing and processing purposes, and it's not driven by something that is necessary to perform the contract. So it's more a business decision and business efficiency driven decision rather than contract performance itself. So where does this leave us? I've listed here 5 key thoughts based on the Uber decision, and happy to open the floor and see if you have any other thoughts or questions. As Sophie mentioned, of course, this decision has been appealed, so we'll see if it stays as is. But in the meantime, it already gives us quite a bit of food for thought. First is that we see a continuing EU trend of interpreting the GDPR strictly from an individual rights perspective. In this case, the AP prioritized an interpretation that ensured actually maximum protection of individuals. But then the question is, how can companies doing business in Europe actually comply with these expectations in practice? For example, we see companies already thinking, and this has been gradually the case, even more so, of data localization in Europe, and whether that can be the answer to a rather restrictive approach that we may otherwise see from supervisory authorities in Europe. Or is it better to follow a belt and suspenders approach that we see other companies doing? For example, we see companies that are certified to the DPF to have DPF certification and have SCCs as well, and potentially rely on derogations if all the rest fails. It's in a way, it's like throw all the papers, all the bureaucracy, like all the red tape, and something will stick, right? So that's the belt and suspenders type of approach. So is that what we should be doing? The second key point, in my view, is that this decision showcases the ongoing challenges of the GDPR and also the fragility of the DPF. We've already had the safe harbor and privacy invalidated. The DPF is already being challenged. So it is an ongoing question of whether the DPF will survive in the coming years, and how can companies prepare for these challenges, also with the incoming US administration, and how this may impact the data transfer landscape, because we're really in a moving sand type of scenario. And I know we've been saying that for the past 5 years. It seems like we've been saying that year and year again, but it is actually true. The last key thoughts, from my point of view, is that one, we see a very fluid definition of data transfers. And again, that is partly driven because we otherwise don't have a concrete data transfer definition under the GDPR. Uber's position has been that the EDPB definition itself is not binding, and that in any event, no transfers took place in the context of the processing for the reasons we explained before. Dutch DPA also set forward an argument that I find quite interesting, which has to do with the degree of influence over the context in which the data is being processed. In other words, the Dutch DPA said that because Uber had this large degree of influence, and in essence, the drivers could not really have a take as to whether their data would be transferred or not, that is an additional argument to consider that this data flow is in fact a data transfer But of course, this leaves us thinking of how should we be considering data transfers in the future. Again, should we be more skeptical with respect and more conservative in how we define a data transfer? Should we follow a belt and suspenders approach or a more risk-based approach? Fourth, that the derogations are consistently interpreted narrowly. We see that this is kind of a backward trend because in 2021, like after the invalidation of the privacy shield, there were some views from specific supervisory authorities as well that derogations can be used more widely than companies thought so before. In a way, back then, derogations were like a hidden treasure that companies started to discover and see if they can rely on them. But we do see that, particularly after the DPF coming into play, that derogations are consistently interpreted in a very narrow way, which leaves us thinking that in practice, can we really rely on them for a consistent data flow, or is it something that is really truly exceptional that we should have at the very back of our head, and unless we cannot rely on anything else, no matter what, we should start considering them? And finally, what are the obligations of a company located in a third country that is directly subject to the GDPR with respect to data transfer restrictions? And there, that is a bit mind-boggling because, in a way, the SCCs that we have now, the new SCCs, were supposed to be for companies that are located in third countries that are not subject to the GDPR. And in fact, we see that we now have the proposed new SCCs from the European Commission that will be tailored to entities located in third countries and subject to the GDPR. In a way that even though it's very clear, at the same time, it adds to the ambiguity because now we have one set of SCCs. In practice, particularly companies that were following a belt and suspenders approach would execute SCCs irrespective of whether they consider that they are or are not directly subject to the GDPR. Now we see that we'll have this new set of SCCs that was not released in 2021. So now we expect that they will be finalized sometime in 2025. So in a way, there is different timing and different dynamic. And those will apply to entities that are subject to the GDPR, which further reiterates the point and enhances the argument that the SCCs otherwise are not supposed to be used if you consider that you are directly subject to the GDPR. So that leaves kind of quite a few questions out there. So even though the intent is to clarify the ambiguity, we'll see whether that happens and whether we'll end up with many different sets of SCCs, with companies trying to figure out again and again what sets of SCCs should they be executing, and if they follow belt and suspenders approach, if they should in fact be executing both different sets of SCCs just in case. So many questions out in the open. I'll pause here and thank you very much for your time and your attention.
Thank you, Nick. So just a reminder for the audience, if you have questions, just use the chat or the Q&A box and don't hesitate to ask your questions. Thank you so much. Nick, you ended on the new set of SCCs. Can you say a little bit more about what you expect to see in this new set of clauses that could be different from what we have already in the existing set of model clauses?
Right. So the details of the SCCs are currently not available. We know that the Commission is working on them. We would expect that the actual content of the SCCs would be quite similar to the existing one, but rather it would be a different set that is tailored for companies that are subject to the GDPR. So it's more a scoping exercise rather than a substance exercise. I'd be surprised if in terms of substance we'd see something that is materially different to what we already have, which is why I think that many companies find that even more confusing, because in a way, if the content is similar and we're just changing the scope, why did we need to wait for 4 years for that to happen?
Okay, and let me ask a question about what you actually see in practice. In the main, what do organizations used to do, just adopt the existing SCC model without listening too carefully to what the European Commission had been saying in its recitals or Q&A dedicated to its decision on model clauses?
Yes, exactly. We've seen that most of the companies are following the so-called belt and suspenders approach because they know that the data transfer landscape is very dynamic. It is a moving target. At the same time, executing the SCCs is a rather straightforward exercise. Like if you're otherwise executing a DPA, for example, it's very easy to just add SCCs to that. So in a way, most companies saw that as something that may be bureaucratic but necessary to do, and in any event, good to just cover our back. So most of the companies would do that just to be on the safe side, and they wouldn't risk with, as you said, like looking into the recitals, taking a more risk-based approach, and having a defensible argument that may or may not stand before a DPA. They'd rather kind of deal with it now and be safe.
Okay, and let me ask another naive question. So assume we had SCCs in place. We know that it's not enough to have SCCs. In some cases, you need to have supplementary measures. Were there a way to protect this data with supplementary? Are supplementary measures needed in such a case? What do you think of the arguments that the transfer would stand if SCCs had been put in place?
That's a great question because we would need those supplemental measures, and we need a transfer impact assessment as well, right? So we add a number of documents that we need to complete, and that's where I'd see a bit more the risk-based approach. So in a way, the risk-based approach has moved from having or not having SCCs, because I think most companies would say just have SCCs no matter what to be on the safe side, to what do we do after we have SCCs. So that's where more companies would differentiate and take a more risk-based approach and maybe not fully complete the supplemental measures or complete them at a high-level basis. The same with the transfer impact assessment. So that's where they would perhaps be more willing to take some risk.
Okay, and going forward, we know that the Dutch DPA has not been very lucky with its interpretation of the legitimate interest, so it tended to adopt a rather restrictive definition, excluding commercial interests. What do you think of its interpretation of the principle of necessity underlying the derogations here? You mentioned considerations related to efficiency, which had been excluded. If you had to bet, what would you say? Could that stand?
It's hard to tell, of course, right? It's a coin flip in a way. I think it's a very narrow interpretation. It's a very strict interpretation. In principle, I think it would make sense to be more mindful of business efficiency, business structure, because companies have been investing lots of money, energy, and resources into how they structure data flows and how they systematize their data flows and why they do that. So I think it'd be a very welcome addition to be more mindful and more open as to how companies operate, and a bit more extrovert to that extent. Otherwise, I think it's a very doctrinal and conservative approach and interpretation.
Okay, and to close this part, what is the part that you like the most in this decision?
The part that I like the most?
Yes, that convinces you the most, if there is any. But
I particularly enjoyed actually the arguments with respect to the WTO, the World Trade Organization, because it's one of the very first times that we see WTO-related arguments that in principle has to do with trade and trading services to be used in privacy-related investigation and litigation. And I think that's an interesting area to explore altogether. And given how the increasing wave of protectionism in goods, we likely see digital protectionism in the rise as well. So I think that more challenges that also will have to do with the WTO will be something interesting to keep an eye out for. So I'll definitely do that.
Okay, thank you. We've got one question from the audience. Hello, and thanks for the presentation. I'm curious to understand what you mean by trend of interpreting the GDPR strictly from an individual rights perspective. Who would you say the individual and who the collective are in the specific case?
So what we meant there was with respect to the data subject rights, right? That there was a very narrow interpretation and protective for the data subjects with respect to what happens with their data, and that from the moment that their data leaves the EU, it is a data transfer no matter what. So it wasn't an individual versus collective type of comparison, but rather individual from a data subject standpoint type of approach.
Okay, although you say it's B2C, but I mean, in this case, the driver obviously are exercising at least the business. Yes, yeah.
Exactly.
Okay, thank you so much, Nick. Turning now to Lucas. Lucas, can you present us the work that the INPD has been doing on SCCs? What stands out in these SCCs and how simple or complex the set is? Was there, for example, any discussion on the distinction between the importers that are bound by the LGPD or importers that are not bound by the LGPD, which would be useful to compare with the European way of doing things? Lucas, the floor is yours.
Thank you, Sophie, and thank you for the Privacy Hub for the invitation. This is a very rich discussion, especially for us. We just completed 4 years of existence as a DPA. So it's like taking a back seat, especially in these discussions. There's an accumulation of administrative discussions in the EU, and it's quite a privilege to be able to see some of the problems that we're going to face ahead, and try to define and have almost like a second mover's advantage to the approaches that we take in terms of regulation, in terms of interpretation, and things like that. I'll present very briefly some of the main points of our regulation, mostly focused on SCCs. And then I'll try to cover or dialogue some of the points mentioned in the previous presentation. So just to be clear in terms of disclaimer, the ANPD decided not to regulate seals, certificates, and codes of conduct as of now. We believe that our market for this specific area and even our institution needs a little bit more maturity. So we decided to focus primarily on other mechanisms for international data transfers, such as SCCs, adequacy decisions, and things like that. Just this month, we were able to publish all of the material related to international transfers in our website, so in English. So also increases accessibility, and if you use the QR code here, you are directed towards our regulation in English as well, which we provided an official translation. And there are some questions and answers there on our website as well. Basically, this is the structure of our resolution. As you can see, we focused primarily on adequacy decisions, SCCs, specific contractual clauses, and BCRs. And this resolution basically proceduralizes how to implement these mechanisms under the LGPD, which is our data protection law. In today's presentation, I'm going to focus specifically on adequacy decisions, but also standard contractual clauses. So the idea of our SCCs, we depart from a different perspective. We decided to focus on this idea of exporter, importer, and not necessarily qualify for our SCC if the agent is a controller or a processor, and then provide different modules for that. Of course, we identified those categories in our SCC, so there are boxes that the data controller or the data exporter will most likely check in order to implement them. So we have this rigidity of the text and not the specification of a dialogue between a processor and controller, or a controller between a controller. So we decided to focus on this definition of a data exporter and importer. You were mentioning the necessity of comparing the GDPR bound transfers or external agents, as we might call it under our jurisdictions. In Brazil, according to our regulation and according to the LGPD, we do define international data transfers. We do define data collection. So we stem from a more prescriptive and legal certainty perspective when it comes to those definitions. If it's a data collection and not an international data transfer, we understand that the entirety of the LGPD will apply to the data processing. And our perspective is that this is a more burdensome compliance mechanism for agents who are processing data, for example, from Brazilian citizens, than just using SCCs. So this idea that SCCs will allow for international transfers in comparison to data collection, which will create a larger set of obligations for data processors or controllers outside of Brazil, for example. So there are some similarities. So SCCs must be incorporated literally in contracts. Other clauses may not diminish the validity of the SCCs as they stand. So it's a quite rigid text as well. And we can identify other similarities and distinctions as well. So enhanced transparency obligations, just like the EU SCCs, the necessity of data subject to be able to exercise their rights. So we can identify some of these similarities, but also there are some distinctions, especially in the legal design. So the scope of applicability, for example. Whereas in the EU SCCs, we have a very party-dependent modular system. So you have to clearly identify and adequate your SCC according to this relationship. We stem from a more uniformized text, even though there are choices to be made while filing the SCCs among the parties. Also, when it comes to specific clauses for onward transfers, I think the EU model is a little bit more prescriptive when it comes to including the clauses related to that. Whereas in the Brazilian SCCs, basically the parties agree to allow or not allow onward transfers. And if they do so, they have to follow the minimum standards set by the SCC. So it creates this chain of responsibility, of liability between the agents involved in the international transfer. And also something that I think it's also related to the Brussels effect, we decided to implement the recognition of equivalent standard contractual clauses from other jurisdictions. We think we're not setting a global standard of data protection like the EU is. So we wanted a mechanism that would make it as interoperable as possible and would allow our DPA, our jurisdiction, to also recognize other SCCs, for example, of the EU or international organizations such as the Council of Europe, for example, or other jurisdictions, SCCs, as equivalent to ours when it comes to protection mechanisms, implementation, that kind of thing. So this is something that we think creates less friction between different systems. We are yet to experience a recognition of equivalent clauses. as you mentioned before, we're focused on other mechanisms at this point, especially the adequacy decision with the EU, and we have a very small team. So, but this is down the line, and we're certainly going to work with that in the future. Just a general structure of the SCCs in Brazil, of course, identification of the parties, responsibilities, general obligations, especially transparency obligations for the data subjects, the rights of the data subject, how to access information about the data processing, and what is the procedures or the measures related to, for example, information security, in the case of data breaches, and things like that. Here's a little bit of the, I'm going fast because I know we have a short amount of time, but I'm realizing that we'll have some questions to discuss things in a little bit more detail. Here's the procedure for the approval of equivalent standard contractual clauses. So the idea that the DPA can consider other SCCs as equivalent, including for international organizations. So I know there are some models out there which can be used. So we're also considering that, but only if they ensure a level of protection that is compatible with our data protection law. This can be done ex officio, autonomously by the board of directors or commissioners, or at the request of interested parties who are already operating under those SCCs and think Brazil is a jurisdiction of interest for them. So this is also a possibility. Our team, which is the technical team on international affairs, will analyze all of the documentation, just like other mechanisms, and will propose a recommendation to the board of directors, and they have the final say in approving those SCCs or not. So this is something that I think it's important to highlight, because it's a little bit different and not necessarily present in other jurisdictions as well. There was some misconfiguration of the slides. Basically, I wanted to highlight adequacy decisions in the end. We're in the process of discussing adequacy decisions with the EU for a while now. Since last year, we have been discussing with the European Commission, and now that we have a regulation that determines the actual procedure of adequacy decisions on our side, we can make it more high level, especially in terms of reciprocity. So for us, and this is present in our regulation as well, it's really important that we establish reciprocal adequacy decisions with other jurisdictions. We think that's in line with diplomatic principles in Brazil. And this is the approach that we're taking with the EU. So we've been doing our homework, the EU as well. So many discussions. It's an interesting exercise. Now speaking from somebody who's on the other side, because it's about setting the line of a possible modulation of this decision. Of course, many adequacy decisions from the EU have certain limitations, and scope. And for us, as the DPA and our Brazilian civil servants involved, we're trying to make it as broad as possible. So this is our intention. But we also understand the context in which adequacy decisions come in the EU. There's a lot of preoccupation regarding, for example, past decisions related to the United States and the Schrems cases, about government access and things like that. This is the concern in the Uber case. This is a concern in SCCs. So currently we're holding meetings with several areas of the government and the European Commission and vice versa. And we're hopeful that by summer next year, we'll be able to have some good news on both sides. Meanwhile, we're already opening initial discussions with the UK right now. I know they just introduced proposal for changes in their data protection regulations, so we're following that quite closely. But the European Union remains our top priority at the moment. I'll be happy to take some questions. Thank you.
Okay, thank you so much, Lucas. Back in May, I think the hope was to get the adequacy decision by the end of this year. So there's been some delay, which is not surprising, I guess, because it's a complicated space. But it's good to hear that we should have something before the summer, you said?
So yes, it's interesting. I've been discussing in some of these events I go to, I discuss with other with partners from other jurisdictions with which the EU has adequacy decisions, and they always say it's an ongoing process and it doesn't finish. I think it's now taking my DPA hat and putting on my academic hat is also part of the Brussels effect in action, because it incentivizes actual change and, to be honest, good changes in terms of interpretation, administrative decisions, and we also have to maintain some particular elements of our own jurisdiction. So it takes a while. We were quite hopeful that it was going to happen by the end of this year. But after the European Commission has a decision or a proposal of an adequacy decision, they also have to negotiate with state members. So it takes a while.
Yeah, I mean, as for every good things, you have to be patient. Okay, so there is one big question, and I'm glad to see that it's also in the chat, which is about the definition of data transfer and the difference between international data transfer and then data collection. And just if we take the facts that we've got in the Uber decision. Yeah, so we've got the drivers sharing data with Uber, contracting with the European entity, but then directly exchanging data with the US entity. What is this under the LGPD? Is this and the new regulations? Is this the data transfer? Is this the data collection? And how do you distinguish both?
As Nicolas mentioned, and I think his analysis was quite careful to break it down into different operations, because these operations are not simple and they're not monolithic. Many sorts of processing will happen within the same business model, and it's important to break those apart and understand which one is for example, a data collection or international data transfer. So I'm just sharing with you really quickly. This is our our regulation on international data transfers, and it clearly defines the three of them. So what is a transfer, what is an international transfer, and what is an international collection of data? So basically, we would distinguish at first the data collection, because it comes from an individual and a data subject, but also an agent located abroad. And it's not systematic. It doesn't represent a business model that is internalized in the country. And we're still waiting to see in practice what are the definitions that are going to appear under that major definition. But then an international data transfer will rely on this transfer of personal data between not necessarily just a controller to another controller, but also processor and different agents for a country or an international organization. So in the Uber case, and this is a personal exercise, it doesn't represent the opinion of the DPA at all. I would say there was data collection for the Brazilian interpretation purposes, and also an international data transfer for Brazilian data protection purposes. But this is my opinion. I cannot say that this is the opinion of the DPA.
Okay, thank you. So as always, the devil is in the details. Although on the face of it, the definitions could look like or similar, we should see how this is going to be interpreted in practice. Thank you, Lucas. And now moving on to Giuseppe. Giuseppe, thank you for waiting. We are a bit late, but we will take the time to listen to all what you have to say about the data free flow with trust initiative. There's been a lot of enthusiasm about the data free flow with trust, which emerged from the G20, went to the G7, and then has been taken up by the OECD. What is this? Could it be like a forum for discussion, a set of standards? And how can we make, in such a context, national and regional regulatory systems really talk to each other and maybe become interoperable, which seems to be the word that is being used to speak about how we should make these systems talk to each other. Thank you, Giuseppe. The floor is yours.
Thank you, Sophie. Thanks to you and to the Process Free Hub for the kind invitation. And I've already learned a lot from Nick and Lucas. As you said, this is like an early aperitif, so I hope this is the presentation will be like a spritz, or at least a virgin mojito. So I'll be very quick in this overview of what data free flow with trust is at the OECD, what work we have undertaken so far, and what we are currently doing, and what we intend to do in the near future. For those who might be unfamiliar with the term, it was coined by late Japanese Prime Minister Abe Shinzo in 2019 at the World Economic Forum, and then taken up by the G7, the G20 and the G7 thereafter. So it's a policy concept aimed at promoting the use of personal and non-personal data for economic and social prosperity while ensuring the protection of fundamental values such as privacy and data protection, intellectual property, etc. So it is interesting to note that it's the first time that data use and data flows are on top of global leaders' agendas, and also that it's a concept that goes beyond just personal data flows. At the OECD, we can say we've been working on data free flow with trust, or DFFT in short, for many years without calling our work DFFT. Already the privacy guidelines adopted by the OECD in 1980 and revised in 2013, which have provided a basis for legislations in different countries, are also about, in their full title, the transborder flows of personal data. Some of our work, a significant part of it, is about building trust about flows of data, especially personal data. That's the case, for example, of the OECD Declaration on Government Access to Personal Data held by private sector entities for law enforcement and national security purposes, a declaration adopted by OECD member countries and the EU in December 2022. And other work that you can see on the slides. I would particularly like to highlight a report on moving forward with DFFT from 2023, where colleagues talk to private stakeholders, legal counsels about the challenges businesses face and ways to leverage the commonalities, complementarities, and the elements of convergence of global data protection frameworks. After this report, the G7 ministers in Japan asked the OECD to operationalize data free flow with trust. And how did we operationalize DFFT? We did so by establishing an experts community, the DFFT community, which assembles roughly 300 experts from more than 40 jurisdictions, including 6 international organizations and regional organizations. So it's experts coming from data protection authorities, as well as government ministries or departments, academics, civil society, industry representatives. And it goes beyond the membership of the OECD, which is made up by 38 countries currently, with 8 in the process of accession. So the purpose of the DFFT experts community is to provide technical perspectives and evidence that will feed into the policy work of the relevant OECD bodies, namely the Working Party on Data Governance and Privacy and the Digital Policy Committee. So far, the DFFT experts community is active on 2 projects that deal with personal data flows, one on cross-border flows and data flows, and the other one on privacy-enhancing technologies in cross-border cases, on which I will tell you some more details. But other projects are currently under consideration, such as the flow of non-personal data. So the first project under the DFFT experts community is cross-border payments and data flows, which sounds maybe quite technical. Well, it is technical, but maybe to understand it better, I'll give you a short background on the G20 roadmap for enhancing cross-border payments. And I guess the really interesting aspect is that it doesn't really happen very often in the international policy landscape, but we have been trying to build bridges and leverage synergies across different work streams and different international organizations. So the G20 adopted in 2020 this G20 roadmap for enhancing cross-border payments to improve cross-border payments with regard to their speed, access, cost, and transparency. And one of the priority actions concerns data frameworks. So basically, cross-border payments have experienced some frictions due to data frameworks, which is how they call very broadly rules determining the flow of data across borders. So we looked at this project. We have been in contact with the Financial Stability Board that has coordinated work from the financial side, and we realized that it could be a very fit project for DFFT, because the dual goal is to protect privacy and data protection while addressing the challenges concerning data flows in cross-border payments. So under the broader DFFT experts community, we have established a specific working group to look at cross-border payments and data flows. So we have roughly 90 participants, and we aim to have a questionnaire to payments operators and participants to look in really large detail at the frictions that they experience and what legal bases and tools for cross-border data flows are particularly apt for this specific sector. So it's one of the use cases to operationalize DFFT in practice. And we interact in a very complex environment. As you can see in the green column, there's the Financial Stability Board, the Financial Action Task Force, because anti-money laundering and countering the financing of terrorism is a huge topic in this area. But also sanctions authorities, the Global Privacy Assembly, and data protection authorities. So we are currently working on this questionnaire with our experts. We look at the main areas of friction, and we also make it future-proof by looking at AI, central bank digital currencies, and innovations that are currently in the making. The second project, I'm going very quickly, but so as not to go too much over our given time, is on privacy enhancing technologies. Here, the OECD adopted a report last year on emerging privacy enhancing technologies, and the report adopted by the OECD, let me just highlight this, means that the Working Party on Data Governance and Privacy has agreed on the contents, so there's consensus among the OECD member countries, and then the Digital Policy Committee adopts and declassifies the report for its publication. So it means that there's consensus across the 38 member countries. So it's something that needs some time to be built, and it's the result of both the efforts of the OECD Secretariat and the political consensus amongst the delegates. So based on the interest generated by this report among our delegates, data protection authorities, but especially I would say government ministries, we have established also a specific working group within the DFFT experts community on pets in cross-border cases. And the idea here is to have reports on pets and AI and a global repository of use cases on pets and artificial intelligence. So far there have been 2 workshops in London and in Singapore, and there will be another one next year with a Canadian G7 presidency. So I'll conclude with the ways forward. We'll continue to work on these 2 projects. As you can imagine, they are quite technical. We have a small staff, but we leverage the collective wisdom of the working groups with the experts that we have set up. Other projects will be added in the near future, and the evidence-based produced by the DFFT experts community will feed into and shape the policy work of the OECD, the working group, and the Digital Policy Committee. And of course, we are always open to feedback and suggestions that you may have. Thank you.
Thank you so much, Giuseppe. That's very interesting. So you are indeed building a community and making it work in sectors to try to better understand what the challenges are and see whether there are ways out. And is it true that then identifying a particular specific use case, then it's suddenly becoming more helpful to apply or develop a risk-based approach to data transfer? Was this the thinking
Yes,
behind?
exactly. So the ambition is, or the idea behind the way we have operationalized DFFT is that it may be productive to look at specific areas, specific use cases. And in the area of cross-border payments, which is the one that I coordinate, we see that there's a need really to build bridges across different epistemic communities or practice communities, because coming from a central bank in my previous life, there's already quite a high level of regulation for operators in the payments ecosystem, but the understanding of privacy and data protection is not extremely well developed, and there's often a need to liaise with data protection authorities, but the channels are not always open at the domestic level. So what we are trying to build is really this mutual understanding. So cross-border payments are useful for the economy. You think of e-commerce, you think of migrants and remittances. That's why the G20 decided to work on the roadmap. We want to ensure that privacy and data protection are taken into account, but we also want to ensure that data can flow along the payments. So looking at the issues, looking at whether there can be some frictions that we can actually demystify by looking at the frictions together from both angles, the financial services authorities, for example, perspective, and the data protection authorities perspectives. We hope that we will make progress in practice.
Okay, so this particular use case is making you be optimistic about.
It's really the beginning, but we had a workshop last month in Rome where we had different people in the table coming from these 2 worlds, and there was optimism in the room, as in this is a good path to build upon.
Okay, and also, yeah, your pets work streams seems also to be very interesting. The hub has been looking at pets in the context of its global landscape project. So I think if I am listening to what you were saying, again, here you're adopting a use case. So you're looking at pets on the use case basis, yes? Pets in general, I mean, it's very hard to speak about them. It's only when you define the setting that you understand what it is that you're actually really achieving.
Absolutely. Already the report last year looked at both the opportunities and the limitations of pets. Mainly the use cases relate to finance, and of course there we leverage synergies with the other working group on payments, and health. So these are the two main areas in which bets are being looked at.
Okay. Okay, any more question? I don't see any in the chat, and it is already past 5:30, so I think it's time to really enjoy your happy hour and move towards Friday. Thank you so much for being with us today. It has been enlightening and has oriented lots of many new questions that we need to be aware of and that we will continue to develop further in forthcoming webinars. Thank you so much all, and see you very soon. Bye bye.
Thank you. Goodbye.
Thank you.